Choose Your Words Wisely, a research study of two defamation cases presented by Sherry M. George. New York Times Company versus Sullivan. The New York Times versus Sullivan was a landmark case that attempted to determine whether a publishing company could be held liable for defamation for printing an advertisement that criticized a public official's conduct. The parties involved are as follows. 1. The plaintiff, L. B. Sullivan, one of three commissioners of Montgomery, Alabama. 2. The defendant, New York Times Corporation, publisher of the New York Times daily newspaper. The advertisement was a full page and was titled "Heed Their Rising Voices" and had been commissioned by members of the civil rights movement based in Montgomery, Alabama. The primary facts of the dispute between Sullivan and the New York Times included the following. 1. A full-page ad was taken out in the New York Times newspaper on March 29, 1960. 2. The ad made allegations of violence against participants in the Southern Civil Rights Movement by public officials. 3. Some claims made in the advertisement were inaccurate. 4. Sullivan was a public official and believed these inaccurate claims could be associated with him and negatively affect his reputation even though he was not explicitly identified in the ad. 5. New York Times did not check the accuracy of claims made in the advertisement and did not retract the ad when asked to do so in writing by Sullivan. 6. Sullivan initiated court proceedings on the grounds that he had been libeled by the statement in the advertisement. Damaged reputation. Sullivan stated that as a result of these libelous claims, his reputation as a public official had been severely damaged. He argued that as the commissioner in charge of supervising the police department, he was the de facto representative of the Montgomery Police. Thus, any use of the word police in association with the negative public behavior alleged in the advertisement could implicate him as the one who authorized it in the minds of readers. He further argued that the statements in the advertisement gave a false representation of the police department and therefore of him. So, his ability to function in his official capacity as a public official had now been seriously affected. In order to win the case, as plaintiff, Sullivan, and as a result of this case any plaintiff, must prove that the published statements were in fact defamatory. To do this, the plaintiff must 1. Show that a defamatory statement was made. 2. Show that it was a fact, not an opinion. 3. Show that it was false. 4. Show that it was made about or concerns the plaintiff. 5. Show that the author knowingly published a false statement that includes the requisite degree of fault. 6. Show that the statement injured the plaintiff in some way and held the plaintiff up to public injury or scorn. After all of the evidence had been presented, both the initial trial judge and the Alabama Supreme Court ruled in favor of Sullivan. The New York Times appealed the case to the U.S. Supreme Court, who overturned both of the lower court's decisions. The Supreme Court instead ruled in favor of the New York Times Company for two major reasons. First, the right to publish those statements was protected under the First Amendment. Second, the evidence provided was insufficient because the plaintiff had not proven that what was published was done with the knowledge that it was false or with malicious intent. The Gertz v. Welsh case was a landmark case that attempted to determine whether freedom of the press created a privileged situation that would prevent liability for defamation of private citizens. The parties involved are as follows. the plaintiff, Elmer Gertz, a Chicago attorney and private individual; the defendant, Robert Welsh, publisher of American Opinion magazine. The article was a full page and was titled Richard Nuccio and the War on Police, and had been written to try to prove that Nuccio's trial for killing a young man was nothing more than a communist campaign to undermine the local police. The facts under dispute in this case were that there were many accusations made against Gertz that were inaccurate. The March 1969 article accused Gertz of being a quote-unquote Leninist and quote-unquote communist fronter. It also alleged that Gertz had been a member of organizations with communist sympathies. The statements were found to contain inaccuracies. Therefore, Gertz sued on the grounds that these inaccuracies damaged his reputation as a respected lawyer and private citizen. More specific allegations against Gertz included statements accusing Gertz of being an official of the Marxist League for Industrial Democracy, a Leninist, and a communist fronter. Gertz was also accused of being an officer of the National Lawyers Guild, which was alleged to be a known communist organization. The managing editor of American Opinion magazine did not attempt to verify the charges alleged in the article. He only added an editorial introduction that credited the article's original author with completing the required verifications. I think that these allegations could have affected Gertz's reputation in one major way. Considering the political climate of the time, which was very anti-communist following America's involvement in the Cold War, the Cuban Missile Crisis, and the Vietnam War, in global attempts to stop the spread of communism, being considered a communist or communist sympathizer would have affected his ability to do business because of the resulting social censure and scorn. Avoiding litigation. Had I been in Welch's position, I would have tried to avoid litigation in three major ways. I would have reviewed the story myself and checked the stories personally. Failing that, I would have fact-checked through an established committee of other reporters in the company. I also certainly would not have implicitly trusted the author of the article. Proving defamation in Florida. In order to prove defamation in the state of Florida, the following major criteria must be met. 1. A false statement must be published about the plaintiff to a third party. 2. The false statement caused injury to the plaintiff. 3. The plaintiff must prove negligence on the part of the defendant when the statement was published. It is also important to note and remember that defamation per se is allowed in Florida under specific conditions. Public officials fall under very broad definitions. Criminal libel is still recognized in Florida under certain conditions. There are a number of defenses and privileges allowed to the media. Neutral reporting privilege is not formally recognized in the Florida Supreme Court, and the statute of limitations for defamation is 2 years. Pertaining to my future work in the communications industry, I believe that the following principles will be invaluable to consider when writing and publishing articles. I must verify all sources of information used for stories I publish. Next, ensure that to the best of my ability, all included information is factual and can be proven as such. I must remember to consider how my readership may perceive and interpret information that I have included in a story. I must also be sure to avoid using incendiary, derogatory, offensive, or accusatory language in my writing. Establishing a process and maintaining it will be invaluable. Therefore, I plan to keep consistent notes on stories and sources, etc. Finally, I plan to ensure that I have done my due diligence before submitting a story for publication. Thank you for viewing my presentation.